Hello, I'm attorney Vince Davis. 2026 marks a massive shift in California family law, and you need to be prepared. From how you file for divorce to how assets are divided, the rules have fundamentally changed to prioritize transparency and safety. We are moving toward a less adversarial system, but the legal complexities are greater than ever before. Let's break down what's new. First, let's discuss Senate Bill 1427. This is the most transformative change to how you enter the divorce process. Historically, divorce was adversarial, one person suing the other, but now we have the joint petition for dissolution. This path removes the traditional framing of petitioner versus respondent. There's no formal service of process because you file together. This eliminates the aggressive summons that often escalates conflict right at the start. It's designed to lower the temperature from day one. Unlike old summary dissolutions, this is available to couples with children, real estate, and long-term marriages, provided there is agreement. You must have a written agreement on custody, support, and property at the time of filing to qualify for this streamlined path. The best part? The mandatory 6-month waiting period begins the moment you file, getting you to the finish line faster. SB 1427 is about reducing conflict and costs for couples who are ready to move forward together. Now let's turn to the financial side. Senate Bill 7111 has fundamentally changed how alimony is taxed in California. As of January 1st, 2026, California finally aligns its state tax law with the federal standards set years ago. For any new orders entered today, spousal support is no longer deductible for the person paying it. On the other hand, it is no longer considered taxable income for the person receiving it for California state tax purposes. This ends the confusing split tax era where state and federal rules were different, which often derailed negotiations. Support is now calculated on a true after-tax basis. This means we have more clarity when drafting settlements. The 10-year rule still holds. For long-duration marriages, the court keeps jurisdiction unless you agree otherwise. This means for long marriages, there is no automatic termination date. You need a strategic plan to protect your future. Moving to child custody, 2026 brings critical protections under Peaky's Law and Senate Bill 331. These laws were created to ensure that child safety is the absolute priority in every custody dispute. The law now prohibits judges from ordering children into reunification camps against their will in cases involving abuse. It also mandates comprehensive domestic violence training for every judicial officer in the state of California. Under Senate Bill 343, child support calculations are also being refined to reflect actual earning capacities and low-income protections. Courts can now direct child support into special needs trusts, ensuring disabled children keep their essential public benefits. The law now prohibits judges from ordering children into reunification camps against their will in cases involving abuse. Our goal is to navigate these rules to find the safest and most stable environment for your children. Next, we need to talk about domestic violence and a legal concept called coercive control. Coercive control is a pattern of behavior that interferes with your free will. It's now a valid basis for a restraining order. The law now recognizes that abuse isn't always physical. It can be emotional, financial, or digital monitoring. In some cases, courts can now issue protective orders lasting up to 15 years, a 50% increase from previous limits. If your spouse is monitoring your movements or controlling your money, the law is on your side to stop it. We use digital discovery to prove these patterns and get you the protection you deserve. New workplace protections also ensure you can take job-protected time off for court hearings or safety planning. Don't suffer in silence. These new 2026 laws provide a shield against all forms of control. Finally, let's address the division of community property in the age of digital assets. California remains a strict community property state, but property now includes your digital footprint. Monetized social media accounts and crypto portfolios built during the marriage are community property that must be split 50-50. The date of separation is critical. Once you separate, your earnings become separate property, even if you still live in the same house. We are also seeing high net worth couples reevaluating trust structures to avoid the 2026 federal estate tax reset. Navigating these 2026 changes requires precision, experience, and a deep understanding of California law. You don't have to face this alone. Call us now at 888-888-6582. I'm Vince Davis, and we are all in this together.